I'm Matthew Stugar. I'm a board member of the Los Angeles chapter of the National Lawyers Guild.
Were you here last night at, when the police raided the occupied Los Angeles?
I was. I got here last night about 7 o'clock and I was down here until, I don't know, 3:30 or 4, and then I went home to man our hotline.
Yeah. And tell me, what was your position last night when the police raided the occupied LA?
I was not actually in the park. I was at First and Broadway because there was a line of officers who were lined up with batons and sort of some less lethal weapons, and there were folks there. There were demonstrators who formed a line in front of them. So I wanted to make sure that everyone respected that the police, respected the demonstrators' rights. Yeah. So I was over at Broadway and First, sort of watching that situation, and then everyone sort of ran back to the park, and I was blocked off at the corner of Spring and First.
Yeah. So the news headed that there were like 300 people arrested last night?
292 is the number I'm getting.
292. What is their status right now?
There have been a very few number of people who have been released. One person we know of has been released on his own recognizance, so he didn't have to post bail. And a few people have been bailed out. The bail is set for $5,000. So the vast majority of them who are unable to come up with $5,000 to get out are still inside. We expect them to be inside until they are arraigned, starting tomorrow morning. And starting tomorrow morning at their arraignment, they'll be able to request a bail adjustment, and their bail should be reduced to nothing or something more manageable, around $100, we're expecting.
So were they resisting arrest? Is that the charges?
No, the charges, almost overwhelmingly, the charges are unlawful assembly or failure to disperse. I talked to one person who picked up a resisting arrest charge. I don't know the details of it.
Is that criminal record? Is that misdemeanor?
They're all misdemeanors. I think even the resisting...
Misdemeanor. Explain misdemeanor.
A misdemeanor just means it's not punishable by more than a year in jail, but what it means practically is that you never really do a year on a misdemeanor. They're very minor offenses. Oftentimes, if you stay in jail a couple days, by the time you get to a judge, sentence you to time served. You do a couple days on it and you're fine, or you take a fine, or you take some probation, or you take some community service.
Here's another example of a misdemeanor that requires the felon to be put in jail, and so we can get a comparison.
Other misdemeanors are things like petty theft, if you steal a CD from a CD store or something like that. Most minor crimes that you can think of are misdemeanors.
So civil disobedience become misdemeanor in the eyes of law?
Depends what the civil disobedience is. Civil disobedience simply means you are breaking the law in the course of a social or political cause. If you there are people that commit arson and claim it as civil disobedience, and that would definitely be a felony. The civil disobedience, like refusing to leave a park, is always going to be a misdemeanor. It's the charges for trespassing and whatnot that would be chargeable there are always misdemeanors.
So correct me, from my understanding is the misdemeanor of civil disobedience is a $100 charge and a notification to appear in front of a judge.
Well, no, not necessarily. There's no sort of charge that's just civil disobedience. The charges are things like a failure to disperse after a lawful order to disperse, or having an unlawful assembly, or things of that nature. Sometimes civil trespass is what they charge civil disobedience with. So there's no sort of this is the charge of civil disobedience and then this is the fine. There's nothing like that.
So the $5,000, talk about that.
$5,000 seems very high for these charges. They're very minor charges. There's a provision of the California Code that for misdemeanors, the arrestees shall be cited and released, which means they would be arrested, processed, and then given a ticket to show up in court at a later date and released. They shouldn't be held until their arraignment, as these individuals are being held. There's an exception to that rule that the city attorney is claiming applies in this situation, that says if the people will go back to doing if it's imminent that they would go back to doing what they were arrested for doing, which in this case was being in the park, that they can be held until their arraignment. We think that that's, frankly implausible. Nobody's storming the park, nobody's doing anything like that. There's no reason to think 292 people would do that. They're not making any individual determinations. They're saying as a group they're going to deny them their rights under the law. So they're being held until their arraignment on the $5,000 bond, at which point it should be reduced.
What's the maximum numbers of days that they can be held without arraignment?
Arraignments constitutionally need to happen within 48 hours.
And so by tomorrow they would find out?
Well, the thing is that judges aren't always super technical about that 48. I think if it went into Friday morning, it would, I don't think it would be I don't think a judge would see it as a miscarriage of justice. So they're going to get started tomorrow. The truth of the matter is it may bleed into early Friday morning.
Can anybody visit these people in jail?
I don't know. I was down at the jail earlier today. I know attorneys can, but I also heard that they closed down the whole visiting earlier to non-attorneys. I don't know if that was the case. There were people down there who were bailing out some loved ones. Some people, came up with the $5,000 or the $500 bond to get their loved ones out, but they didn't get a visit beforehand. They had to wait outside until they were out. So I don't know what the visiting situation is, but I've heard secondhand accounts that it's closed to the public.
I'm pretty sure I haven't asked you all the right question. If you want to tell us some stuff that I don't know technically, law language, or you as a National Lawyers Guild person, fill us in, please.
No, I think you hit all the salient points. Thankfully, the PD's office has stepped up and agreed to something that's called waiving conflicts, which means they for all 292 people who are comfortable with the PD representing them, they will be represented by the public defender, which is good because they have resources and good lawyers, and they've agreed to take a political tact on these cases, which is good, and not just try to make people plea out to something early on, take some bad deal. So that's good, and the Lawyers Guild is still there to sort of act as backup support for some people who, for political reasons, don't want to go with the public defenders. We're going to try to find lawyers for those people. We can't make any guarantees, but we have lawyers who are willing to jump in.
So maybe my last question is, individually, each one of them has to appear in front of the judge?
Yeah.
Or could it be a class or a group action?
My experience with these both as somebody who's been arrested in mass arrests at protests and someone who's been a lawyer involved in mass arrests at protests is they normally take everybody not into the courtroom but into a holding room outside the courtroom. The PDs will address everyone there and sort of take a few questions and answers, and then they'll take people one at a time into court to arraign them, so that it sort of happens in mass, but it's one mass group and then they go one at a time fairly quickly.
Anything else you would like to add?
Nope, that's about it.
All right, thank you very much for your time.
No problem.
I appreciate it.